So, Sarah, it's common knowledge, I think, that any family applications that are made these days, or any family troubles, I should say, disputes about money or about children, if they end up in court, it's a bun fight. It's delayed and delayed. And then you and I both know that quite often, at the very last minute, the hearings don't go ahead. So there are alternatives, aren't there, Sarah?
There are many alternatives.
You and I both trained mediators.
Yeah.
You've got many years' experience as a mediator.
So we're both accredited mediators. I've been dealing with family law for over 30 years. I trained originally back in 2008, and subsequently I've trained in direct consultation with children, and also more recently in hybrid mediation. And the one thing over all these years that the job has taught me is that the more that clients can do to control their outcome and look after themselves in the process, the better they'll be doing by themselves and their children. And
Absolutely.
I can't emphasize that enough, and that's a conversation I will always have with clients. And mediation is one of those processes that help clients to keep control over the costs, the timing, and hopefully, particularly if there are children, but even if there aren't, for them to come out of that process having sort of worked through it with dignity and having a good working relationship, or a form of relationship with the other person moving forward. So there are so many positives in terms of trying to resolve it. It is a voluntary process, though, as you know, Anne, and so it doesn't work for everybody.
How does it start, Sarah? How does it start?
So the role of a mediator is to help clients reach a consensus within the shadow of the law. And if somebody decides that they want to explore mediation, or even if they wanted to, as you say, make a court application, either in respect of children or finances, they first of all, the government says that they must attend a mediation information and assessment meeting. And the idea of that is to encourage an alternative process to court. And so they would get in touch with us here at Scott Bailey, either by email or giving us a call, and some information. We have a good, clear information pack that we would send out to the client and also to their other half. So everybody gets the same information. And we would book an appointment. And that mediation information and assessment meeting, that initial appointment, is just to really sit down with the client and explain in great detail how we run our mediations, how it works, what other options are available. And another important aspect of that is to think about whether or not it's suitable for them.
Yes.
Screening, as you know, is a huge part of that initial discussion. Yes. And that's why those meetings normally take about an hour, 45 minutes to an hour, and those meetings are confidential.
Yes.
So the idea is that you can relax down and speak to me or you about how what's gone on in the relationship, whether or not there are any concerns about sitting in a room with the other person, how that might feel in terms of the dynamic, and also being able to freely speak so that we get a very clear idea of what's important to that client. And so we would conduct those separate meetings, those confidential meetings, and if we assess it to be suitable and if the clients want to go ahead, and that can either be by way of direct meetings in our boardroom here at Scott Bailey, or we could have that on a Teams or Zoom meeting so we can be online.
We got very used to that, Sarah, didn't we?
During lockdown, absolutely. Yes, and of course, with the building here, we can also accommodate shuttle mediation, which is where the mediator, you or I, would go between the rooms so the clients wouldn't actually have to be together. And there are certain circumstances where that's entirely appropriate. And I think here we're able to offer a very good service for shuttle mediation because there are separate entrances into the building.
Yes.
And we can see clients on different floors even, so they may never need to meet. So we have those mediation information assessment meetings. We communicate the outcome of each of those meetings to the other person. And if
although
we go ahead,
the meetings themselves are confidential,
absolutely.
aren't they? Yes,
so we
yes.
don't discuss the content of the meeting, it's just the outcome. But if everyone wants to go ahead, then we would set up a series of meetings and see how we go. The meetings are secret, they are without prejudice. So again, the idea is that everybody can relax down about what they discuss and what's important to them and their options, really. So, and as I say, we can't give legal advice.
No.
You can have your own solicitors for that. But we can give lots and lots of legal information.
We can,
and we can't judge it. Often clients, they want us to judge it, don't they, Anne?
They do.
We can give lots of legal information, and hopefully there will be a good path to be steered to help clients reach their own conclusion and their own consensus within the shadow of the law. That's the important bit, really.
Absolutely. And our role, really, as a mediator is to facilitate the two of them reaching some proposals that they can live with. And of course, the more input a couple has into their own decisions, the more likely they are to stick with them, aren't
Absolutely.
they? And that initial MIAM meeting is £250 plus VAT. That's what we charge, isn't it?
Yeah.
And then, of course, there's a saving if you're a couple within mediation, because you're sharing generally the costs of that going forward.
That's right. And the mediation themselves, we charge that at our hourly rates, but of course we don't charge for any letters going out or anything other than pure work on documents and the actual meetings and the preparation of the session notes, because we will also always prepare some session notes at the end, which are sort of neutral reflections on the discussion. And it's very helpful for the clients to have those because they can give them to their solicitors and also just reflect on what's being discussed. And the other thing to say is that, of course, you and I, we're quite careful not to run very long meetings.
No.
It is really important that clients have time to step back and reflect and are not exhausted by the process. I'd much rather have short meetings at more regular intervals, so maybe 1.5 to 2 hours, maybe going on a little bit beyond that if everyone is keen and willing to do so. But, you know, everybody gets tired. So I think that's the best way, because then people are in the best place to make important decisions about their future, really.
And another benefit, of course, is that the clients can choose when they'd like those meetings. I mean, we can facilitate within reason when they would like to come in, which is completely converse to the court process. As an example, and I'm sure you've done similar, Sarah, over the last couple of months, I've concluded a mediation and we had 8 meetings, and that took maybe 3 months. If you're comparing that to the court process with 8 court hearings, you're probably looking at 2 to 3 years, aren't you, with the delays that are inherent in those at the moment.
I mean, it is, you know, the court system, particularly off the back of COVID, you know, they are really struggling to cope with the backlog. And of course, you know, there is still, you know, people are still unwell and things get delayed. And, you know, lack of judiciary, I mean, that's a very common one.
There's a massive shortage of judges, aren't there, at the moment?
So the whole system is just, it is far better that people take control of it and resolve it in a different way. The other aspect, of course, is that we have joined the Ministry of Justice voucher scheme.
We have.
And so if clients are mediating about children, we are able to apply, subject to certain consents given by the clients about data collection for the government. We're able to apply for a voucher for £500 towards their actual mediation sessions.
It's really useful, and that works very well, actually, doesn't it?
Yeah.
And I think you had a case where that £500 covered just one session where the matter was resolved. That is unusual, but possible.
Absolutely.
So that's quite helpful to know.
And again, you can see that, you know, the direction of the way that, you know, the courts don't want to deal with matters.
No, they don't.
Bottom line is they would far rather people made their own decisions with informed and good advice, really.
I think one of the, moving on from that slightly, is the Bournemouth Court are piloting the Pathfinder project, aren't they?
Yes.
So ordinarily, couples, if they made an application to court, and this is still the case in a lot of courts around the country, they would automatically get a hearing within a certain amount of time. But the courts are recognising that these other processes are far more beneficial to families where there are disputes over children. And so, as you know, Sarah, the Pathfinder project is encouraging, even upon a court application, for those couples to be referred to some other kind of resolution, i.e. mediation. Yeah. So it's sort of going in a big circle, isn't it?
And quite right.
Yeah, so we have a big mediation practice here. You and I are both accredited mediators. And so, but that said, we can still facilitate meetings fairly quickly upon consultation.
Yeah.
Thank you, Sarah.
Thank you.